welcome to Litigation Help. My name is Heather Hui-Litwin, and today we're going to talk about how to prepare for family mediation. So joining me here today is our regular guest, Laura Tarcea. Hi, Laura.
Hi, Heather. Nice to be here again.
Laura, could you please give us a few pointers on how one would prepare for a family mediation?
Sure. So there's a couple of things that I think are important for first, and I think we covered at some point, is just to research a little bit around, what mediation is, if that's the path that families want to take. And then one of the things that I really do think it's important is before engaging in mediation, or even during the mediation, it would be a good idea to have legal advice. So maybe consult with a couple of lawyers just to understand a little bit of the rights and the responsibilities, obligations moving forward. That doesn't mean you have to engage a lawyer for a litigation or anything like that. It's just, get a sense of your legal rights and entitlements. And then in the mediation, I think what's the most important aspect is that after, a mediator would only be able to tell you, to give you a comprehensive list of what you should be preparing for once they have conducted an intake. So once you engage in a mediation, you first have to start with an intake, with a one-on-one with each person individually. And after that, the mediator will put a list together of the documents or of the things that one should prepare. It's a case-by-case basis, right? So I can delve a little bit in that if you wanted to know about that list. We do have a quite comprehensive list that we share with clients all the time, or with families all the time.
Right. Yeah, because you've actually hit that first question I have prepared, and because I was a little bit curious, because coming from as a lawyer, we're very obsessed with prescribed forms and what have you, right? Like form this, form that, form 13, form 17. And I'm just wondering, for the mediation briefs, I believe that the parties have to prepare mediation briefs. So are these prescribed forms or not?
I mean, we always, so other mediators will probably do it differently, but we always do want families to at least either prepare form 13.1 or 13, depending if there's property involved or not, or the net family property statement, financial statement. We do it together in the mediation. So what we do, we ask them to prepare the documents prior to entering mediation. So they'll be So we'll have sort of a productive meeting. So once they have the documents together, then we can plug in the numbers together and discuss what that looks like in terms of an equalization or property division together transparently.
That's amazing. That's completely different from what I expect, because you know how in litigation, everybody just goes off to their secret corners, right?
Yes.
and they prepare their own versions of whatever, and then they come and argue. So here you're actually saying that you just have like the supporting material, the documents, and you fill it in together, which is so much better because you're all working on it together collaboratively.
Yes. And I think that's very important, because it's a very unique opportunity. It is unique because that's the only opportunity in a collaborative space to be able to work together on that form, on the net family property statement as a team, and also receive the information at the same time, right? So understand, because sometimes rightfully so, some family members are prepared. They do understand some of the math, and some really do not understand some of the numbers. So some are a little bit less, or some are a bit more sophisticated in terms of the math and how it works. So this gives us the opportunity to also explain how this form works. Why are some numbers plugged in this way? What are some tax consequences? So everybody hears at the same time the same information, and also gives them the opportunity to ask clarifying questions and hear the answer at the same time as the other person.
That sounds really great. So I have a question. I know that a lot of times that there's perhaps some power imbalance, maybe, and I know that doesn't mean that automatically you cannot go to mediation, because I think I've heard of shadow mediation and so on. But I'm just wondering, like, suppose one party tends to get intimidated by the other. What tips would you say, what recommendation would you say to these people who are already kind of feeling timid and apprehensive? How should they prepare?
And this is exactly why the intake is very important, because in the intake, we get that information from that respective client, whether there is intimidation, whether there's a power imbalance, whether we need to restructure or structure the mediation in a way where their voice is heard, their opinion is at the table, and if there are any power imbalances, we manage them accordingly. So some of the tips are, once you enter the mediation, once you enter the intake, really is to share that with the mediator. So share some of the concerns. What are the concerns? I feel intimidated. I have a hard time seeing him or her during, the meeting. I have a hard time hearing the other person, right? So all of these elements will translate into sort of a prescription of how we're going to arrange the mediation. So one of the things that you had mentioned, it's a shuttle mediation. So sometimes we have families who say, I can't see or hear the other person, which is okay, as long as he keeps it productive and he keeps it outside of the litigation and the adversarial space. Then we're still able to move forward with the mediation by having the mediation conducted in separate rooms. So we would go between the two rooms. The parties would never hear each other, they would never see each other in the space during the mediation. So it would be it will alleviate lots of the concerns that they have, and the tension, and probably the frustration or other emotions at the table. So managing emotions, it's an important aspect of how we move forward, not just the financial aspect of it, right? So there are two major aspects that families need to work on with the mediator in order to manage them appropriately, from the financial perspective and also from the emotional perspective, because we all know that they really influence one another, right? Emotional really can dictate a different financial arrangement sometimes, right?
Absolutely. So I hear what you're saying is that if the parties are in separate rooms and they're actually negotiating through a neutral mediator, actually just that very setup will actually facilitate a more problem-solving sort of mindset, I suppose, and just kind of like eliminating that whole emotional triggers and so on. There's another common comment that I get from some of my clients, and they're very worried that in a mediation they will be manipulated by the other side. So not so much the bullying or power imbalance, but some people will feel that maybe the other side is trying to pull a fast one, that kind of thing. So then they feel apprehensive. Like, what would you suggest to these people who are kind of worried about this, about being manipulated?
So I think it depends. It depends what the context is, because it's quite surprising sometimes when families realize that once they enter mediation and they have discussions about financial division or other elements, the context of where they would usually be feeling manipulated doesn't exist in the negotiation for the financial, right? I mean, numbers are numbers. It's pretty dry. It's pretty mechanical in nature. So there's not much room to feel manipulated or it's hard to transplant the context that if it's a family dynamic necessarily into the mediation. So what I generally say to families, and we have this comprehensive discussion all the time, is what are some of the elements where they feel they may be intimidated? So whether it's emotional, whether is if they still live under the same roof, what can we do in order to prepare that if there are uncomfortable conversations during the mediation, they don't spill into the family dynamic after the mediation, post-separation, post-mediation, right? So we have resources that we share with clients. So on top of the fact that we speak about how we can navigate certain things, we have resources that we share with the clients before they enter mediation to make sure that they do manage emotions, that they allow privacy, they allow boundaries, that there's a whole list that we ask them to review and adhere to depending on their context. Needless to say, I know in a long-winded way, if somebody feels manipulated, I think it's a context-based, and we have to figure out where and how that may impact, because really, truly, some of those elements do not transplant into the mediation conversation or the negotiation. They just don't. We never touch on them because they don't belong in the financial discussion, for example. Right? I mean, some of the things that are negotiated in mediation are very new to the parties, so they would not really interfere with what they feel it would mean manipulation for them.